It is with some hesitation and trepidation that I'm going to spend a segment or so to try and explain what's happening to this benighted hooker law. When Bill C-49 came in, there were warnings from people like Tony Serka that it looked like it was full of holes. Now, Mr. Serka has just obtained a decision on a pre-trial issue from a magistrate which shoots a couple of big holes in it. But first of all, let me ask you, Mr. Serka, has your client yet been tried on this particular soliciting offense?
No, this was a pre-trial motion. It was a constitutional submission to say that the entire legislation was vague for uncertainty.
And what did the judge decide yesterday, the provincial court judge, Mr. Libby?
Well, Judge Libby decided that whilst most of the section is not vague, he ruled that two parts of it, in any place open to public view and the definition of public place, went too far from the purpose. The purpose of the legislation was to combat street solicitation. The effects of it are different. They practically stop all sorts of prostitution. Prostitution in cars, prostitution in West End apartments, because it's in public view. So he excised that part.
It's difficult to understand. Okay. I know that you were complaining earlier on about the use of the phrase "to communicate with any person."
Yes.
But in the open it says, every person who in a public place or in any place open to public view. And then it brings in all the things about the traffic and the communication for the purpose of engaging prostitution.
Yes.
How can that mean in an apartment, Tony?
Oh, in any place open to public view. That means that it can be a private place that the public can see into. So
or
that could be an
into.
apartment, or go into, or
like
a telephone booth. Well, although the public have access to that, but a private place. A private place can become a public place under certain circumstances.
Like going into a bar.
Right. No, but a bar is a public place because the public have access to it.
So there's a nice definition of in any place open to public view.
Right. But if you take that out, what you have left is public place. And since you don't have a definition anymore, you go back to Deborah Hutt. And Deborah Hutt said, amongst other things, and it was a Chief Justice who agreed with this decision, that a police officer's motor vehicle is not a public place, but it's a private place.
So therefore, when we come to public place, we then come to the tactics used by Vancouver City Police in putting undercover operators in an unmarked police car.
Right. As you know, just about all the prosecutions are done by undercover policemen. And how they do it is they drive up in a car and they inveigle the prostitute to get inside the car, then they talk about the deal, and that's it. If it's only communicate, that's it. That's all they need.
Yeah, I know, but the fact is that that previous public place, or that police car, is now a private place.
Well, it's now a private place according to Judge Libby, but another provincial court judge could say, well, I don't agree with Judge Libby. He might agree with my entire argument, or he might reject my entire argument.
It's very difficult for the ordinary person to understand. I mean, I can understand what you're telling me, but on a common sense reading, which is, I presume, what Crosby did, it makes sense to me. In any place open to public view, that's like in a lane or an alley or a parking lot.
That may be what he meant, but a penal statute it can't be vague. You have to, first of all, look upon it as to the plain English meaning of the words. And that's because a citizen must know if the activity that he's doing is criminal or non-criminal because of the penal sanctions attached to doing a criminal act.
Yeah, but there's no argument that this would apply to sexual intercourse in a parking lot.
Well, it doesn't matter about sexual intercourse. All that matters is the communication. Like the act of prostitution is still right, but it's talking about it which is illegal.
What the devil happens now? Does that mean there are 190 odd cases or something?
Yes.
Will they now all be held up until you or the Crown appeals this Libby decision?
I've heard various public reports from the Crown, and I don't believe they're going to do that. I think they're going to continue on.
As a matter of fact, I forgot the Attorney General told me this morning that they're going to continue the normal enforcement.
Yes. Although the police now say that they may change, or they are going to change, the way that they gather up evidence.
Is this a clear example of sloppy drafting of a bill in Ottawa?
I think that's exactly accurate, and that's exactly right. If you look at one of the examples, it says every person who stops or attempts to stop any motor vehicle for the purpose of obtaining the services of a prostitute